Greeting everyone. Welcome to our presentation on navigating employment discrimination laws, a guide for company managers. Today we'll delve into the essential aspects of employment discrimination laws and their significance in the workplace. Employment discrimination laws are critical for fostering inclusive and equitable workplaces. Compliance ensures fair treatment of employees, minimizes legal risks, and contributes to a positive corporate culture. Our objectives today are to enhance your understanding of federal and state legislation, analyze key case law, identify potential areas of discrimination, explore best practices for compliance, discuss risk management strategies, and address any questions or concerns you may have. One of the key aspects of employment law is federal legislation. Here are three important ones for your consideration today. Title VII of the Civil Rights Act of 1964, the Americans with Disability Act, also known as ADA, and the Age Discrimination in Employment Act, also known as ADEA. Title VII of the Civil Rights Act of 1964 is a landmark federal law that prohibits employment discrimination based on race, color, religion, sex, or national origin. It applies to employers with 15 or more employees, labor organizations, employment agencies, and federal government agencies. Title VII makes it illegal for covered employees to discriminate in hiring, promotion, termination, compensation, and other terms and conditions of employment. It also prohibits harassment and retaliation against individuals who oppose discriminatory practices or participate in investigations or proceedings related to discrimination. Title VII established the Equal Employment Opportunity Commission to enforce its provisions and investigate complaints of discrimination. Overall, Title VII aims to promote equal opportunity and eliminate barriers to employment based on protected characteristics. The Americans with Disability Act, ADA. In the realm of employment, the Americans with Disabilities Act, ADA, is a federal law enacted in 1990 to prohibit discrimination against individuals with disabilities. It mandates that covered employees, those with 15 or more employees, provide equal opportunities to qualified individuals with disabilities in all aspects of employment. This includes recruitment, hiring, promoting, training, compensation, and termination. The ADA also requires employees to make reasonable accommodations to enable individuals with disabilities to perform essential job functions, unless doing so would impose undue hardship on the employer. Additionally, the ADA prohibits harassment and retaliation against employees who assert their rights under the law. The law provides enforcement mechanisms through the Equal Opportunity Commission, allowing individuals to file complaints of discrimination and seek redress of violations. Overall, the ADA aims to promote equal access opportunity and includes individuals with disabilities in the workplace. Disability defined. In the federal level, disability is a three-pronged test. A physical or mental impairment that substantially limits one or more major life activities, a record of such an impairment, or being regarded as having such an impairment. And I'm not going to read all of these down here for you, but I have included them for your reference so that you know what they mean in more detail. The California definition of disability is even more extensive. It does include the definition from the Americans with Disability Act, and it does have, again, more information than the Americans with Disability Act, and it includes the Americans with Disability Act. Disability accommodations. There is a balancing test that needs to be done when an employee needs an accommodation. The balancing test for disability accommodations involves assessing the reasonable accommodations needed by individuals with disabilities against the legitimate interest of the employer. It aims to determine whether providing the accommodation would impose an undue hardship on the employer's business operations. Here's generally how the process works. The employee makes the request, the employer makes an assessment to see if there's any undue hardship, meaning it's going to be pretty expensive or that it can't be done easily by the employer, such as having to maybe install an elevator for a 5-story building or something like that. And then the interactive process is to go back and forth between the employee and the employer to find a workable solution if one exists. And again, there are legal standards that guide this process. And under the ADA, employers are required to provide reasonable accommodations to individuals with disabilities, unless doing so would impose an undue hardship. The Age Discrimination in Employment Act, ADEA, is a federal law enacted in 1967 to protect individuals who are 40 years of age or older from age-based discrimination in employment. The ADEA applies to employers with 20 or more employees, labor organizations, employment agencies, and federal government agencies. It prohibits discrimination against older workers in various aspects of employment, including hiring, promotion, compensation, training, and termination. Under the ADA, it's illegal for covered employers to make employment decisions based on an individual's age or to harass employees because of their age. The law also prohibits mandatory retirement based on age, with limited exceptions for a certain bona fide executive or high-level policy positions. The ADEA provides individuals with legal recourse through the Equal Employment Opportunity Commission, allowing them to file complaints of age discrimination and seek remedies for violations. Overall, the ADA aims to promote equal opportunity, fair treatment, and dignity for older workers in the workforce. And you thought I was only going to read to you. I don't like reading to you, but there's so much good information out there, it's hard not to just read it right off the page. Anyway, I do have some questions for you today, and here's the first one for Title VII of the Civil Rights Act of 1964. This is a landmark legislation prohibits discrimination based on various protected characteristics. Now, again, here's that question. What are some of the protected characteristics under Title VII? A. Sex, religion, and national origin. B. Age, gender, and political affiliation. C. Gender, sexual orientation, and education level. Or D. Gender, marital status, and height. Just click on my face down at the bottom right to pause it. Otherwise, you're going to hear the answer before you get to think about it. The correct answer is A. Sex, religion, and national origin. Title VII protects individuals from discrimination based on race, color, religion, sex, and national origin. Moving on to the Americans with Disabilities Act, ADA, which prohibits discrimination against individuals with disabilities and mandates reasonable accommodation. Here's a question for you. What is a reasonable accommodation under the ADA? A. Any accommodation requested by an employee. B. An accommodation that imposes undue hardship on the employer. C. An accommodation that eliminates essential job functions. Or D. An accommodation that requires significant financial investment. Correct answer is B. An accommodation that imposes undue hardship on the employer. A reasonable accommodation is any modification or adjustment to a job or work environment that enables a qualified individual with a disability to perform essential job functions without causing undue hardship to the employer. Lastly, the Age Discrimination in Employment Act prohibits age discrimination against individuals who are 40 years of age or older. Here is a question. What is a key age-related employment practice prohibited by the ADEA? A. Offering early retirement incentives. B. Considering age as a factor in hiring decisions. C. Providing preferential treatment to younger employees. Or D. Requiring all employees to retire at a certain age. Correct. B is the correct choice. Considering age as a factor in hiring decisions. The ADA prohibits discrimination based on age in all aspects of employment, including hiring, firing, promotions, compensation, job assignments, and training. Now, let's shift our focus to California legislation, specifically the Fair Employment and Housing Act, FEHA, and the California Family Rights Act, CFRA. The Fair Employment and Housing Act is a California state law that prohibits discrimination and harassment in employment and housing based on protected characteristics. FEAH covers a wide range of protected classes, including race, color, religion, sex, gender identity, sexual orientation, marital status, national origin, ancestry, disability, medical condition, genetic information, age, and military or veteran status. The law applies to employers with 5 or more employees and prohibits discriminatory practices in hiring, promotion, compensation, termination, and other terms and conditions of employment. FEHA also prohibits retaliation against individuals who oppose discriminatory practices or participate in proceedings related to discrimination complaints. Additionally, FEHA mandates employers to provide reasonable accommodations for employees with disabilities and requires employers to provide leave for pregnancy, childbirth, and related medical conditions. FEHA is enforced by the Civil Rights Department, CRD, and provides avenues for individuals to file complaints and seek remedies for violations of the law. Overall, FEHA aims to promote equal opportunity, fairness, and dignity in the workplace and housing market throughout California. California Family Rights Act applies to employers with 5 or more employees within 75-mile radius and covers most public and private sector employers in California. To be eligible for CFRA leave, employees must have worked for their employer for at least 12 months, have worked at least 1,250 hours during the previous 12-month period, and work at a location with at least 50 employees within a 75-mile radius. CFRA provides job protection and continuation of group health benefits during the leave period, and employees are entitled to return to their same or comparable position upon their return from the CFRA leave. The law also prohibits retaliation against employees for exercising the right under CFRA. CFRA runs concurrently with the federal law and the Medical Leave Act, FMLA. For eligible employees, the employers must comply with both laws when providing leave to employees. On this slide, you'll see a couple cases that I'm going to go over on the preceding slides, or the following slides. And I'm not going to name them all, but you'll see the citation down at the bottom. Some of them have some precedent that was set in there that we now use terminology based on those cases. So here you go. For example, here's the first one. So disparate treatment. Disparate treatment refers to a form of discrimination where individuals are treated differently or less favorable based on protected characteristics such as race, gender, religion, disability, and other factors. This type of discrimination occurs when an employer intentionally treats individuals differently based on their membership in a protected class. It involves overt action or policies that directly discriminate against certain individuals or groups, often resulting in unequal treatment or opportunities in employment, housing, education, or other areas. Disparate treatment is prohibited by various anti-discrimination laws and can lead to legal consequences, including civil penalties and lawsuits. Disparate impact refers to a form of discrimination that occurs when an employment policy or practice, although neutral on its face, disproportionately affects individuals of a certain protected characteristic, such as race, gender, or disability, negatively impacting their employment opportunities. Unlike disparate treatment, which involves intentional discrimination, disparate impact focuses on the unintentional, yet discriminatory, effects of policies or practices. To prove disparate impact, statistical evidence is often used to demonstrate the disproportionate adverse impact on a protected group. If such impact is proven, the burden shifts to the employer to justify the policy or practice as job-related and consistent with business necessity. If the employer fails to do so, the policy or practice may be deemed unlawful under anti-discrimination laws. Hostile work environment. Harris versus Forklift Systems, Inc., 1993, was significant because it clarified the standard for establishing a hostile work environment under Title VII of the Civil Rights Act of 1964. In this case, the Supreme Court ruled that a plaintiff does not need to demonstrate psychological harm or severe emotional distress to prove a hostile work environment. Instead, the court established that a hostile work environment can be established if the workplace is permeated with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive working environment. This decision set a precedent that has been widely applied in employment discrimination cases. Emphasis that Title VII protects employees from a broad range of discriminatory behavior regardless of whether it causes tangible psychological failure to engage in the interactive process. California Fair Employment and Housing Commission versus Gemini Aluminum Corp., 2014, was significant because it addressed the issue of disability discrimination in the context of reasonable accommodation under the California Fair Employment and Housing Act, FEH. In this case, the California Court of Appeals held that an employer's failure to engage in the interactive process to identify and implement reasonable accommodations for an employee with a disability constituted discrimination under FEH. The court emphasized the importance of the interactive process as a means of determining effective accommodations that would allow qualified individuals with disabilities to perform their essential job function. Retaliation refers to adverse actions taken by an employer against an employee in response to the employee's participation in protected activities, such as filing a complaint of discrimination, reporting illegal behavior, or engaging in any other legally protected actions. These adverse actions can include termination, demotion, harassment, or any other negative treatment aimed at punishing or discouraging the employee from exercising their legal rights. Retaliation is prohibited by various employment laws, including Title VII of the Civil Rights Act, the Americans with Disability Act, and the Age Discrimination in Employment Act, among others. Employees who experience retaliation may have legal recourse to seek remedies such as reinstatement, compensation, or other forms of relief. Now let's explore potential areas of discrimination within the workplace. Workplace discrimination is not just in the active work area. It can take place anywhere from hiring all the way to termination or retirement. So you got to be careful during recruitment and hiring when deciding to give accommodations or not for either disability or religious beliefs, when writing and enacting or enforcing policies and practices. Those need to follow due process. Um, Performance evaluations need to be fair. Promotions and advancements need to be fair, as well as adverse actions that take place need to be clearly spelled out before you take those actions, and you do need to take those actions evenly amongst your employees if needed, such as disciplinary actions and termination. Some best practices for compliance include establishing anti-discrimination policies, providing training for management and employees, implementing fair hiring and promotion procedures, accommodating disabilities and medical conditions, and religious beliefs and practices, responding to discrimination complaints as well. Risk management strategies include conducting regular audits of employment practices, maintaining documentation of hiring decisions and accommodation requests, engaging legal counsel for guidance and compliance review. So, we are nearing the end of our training today, and I thought I'd give you a couple pretty simple scenarios that you guys could work with here and talk about for a few minutes, and then I will reveal the answer for you. So here's a hypothetical scenario number 1. An employee requests a modified work schedule due to a medical condition. However, The company denies the request, stating it would disrupt business operations. Is this discrimination? Yes, this could be considered discrimination under the ADA. Employers are required to provide reasonable accommodations to qualified individuals with disabilities, unless doing so would impose an undue hardship on the business. Here's the hypothetical scenario number 2. During a job interview, the hiring manager asks a candidate about their plans for starting a family. Is this permissible? No, this is a violation of Title VII and FEAH, which prohibit discrimination based on pregnancy or childbirth related conditions. Employers should avoid asking questions related to family planning during interviews. Instead, they should ask questions like, are you willing to work nights or travel for employment? Things of that nature. And here's hypothetical scenario 3. An employee files a complaint alleging racial discrimination. The company conducts an internal investigation but fails to take any corrective actions. Is this sufficient? No. Employers have a duty to promptly and effectively address discrimination complaints. Failing to take appropriate corrective action may expose the company to liability under federal and state anti-discrimination laws. So, here we are at the conclusion. Again, today we've talked about federal and state laws and some of the case laws that led to some of the words that we use in employment discrimination, such as disparate treatment, disparate impact, retaliation, and accommodations. Um, Again, it is very important to be proactive in employment, in your area of employment, so that you can avoid situations that include discrimination. And this covers a wide range, all the way from pre-hire to retirement or termination. And you do have to have a very well laid out plan that you follow consistently to avoid employment discrimination. And you want an environment that is inclusive and equitable, and you want people to feel welcomed so that you do not get hit with a lawsuit, and that you have a positive work environment that is safe to work in, one, and two, if something does arise, that it can get resolved quickly and it can be remedied before it turns into a lawsuit again. All right, let's go to the next slide. Hey, congratulations, you've made it through this training for today. This does bring us, however, to the question and answer session portion of the presentation. If you guys use the app, you can send me any of the questions that you might have, and we can have a discussion, and we can talk about any concerns or scenarios that you like. Oh, great. I already got first question. What steps should a company take if an employee feels that they've been discriminated against, but there's no clear evidence of discrimination? Well, that's a great question. When an employee alleges discrimination without clear evidence, it's essential for the company to take the complaint seriously and conduct a thorough investigation. This involves gathering relevant information, interviewing witnesses, and reviewing any pertinent documents. Even if there's no clear evidence of discrimination, it's critical to address the employee's concerns transparently and ensure that they feel heard and supported throughout the process. I hope that answers your question. Here's the second one. How can we ensure that our hiring practices are fair and free of bias? Another great question. So ensuring fair and unbiased hiring practices is essential for promoting diversity and preventing discrimination in the workplace. To achieve this, companies can implement several strategies, including using standardized interview questions, establishing diverse hiring panels, providing unconscious bias training to hiring managers, and regularly reviewing recruitment processes for any signs of bias. Additionally, adopting blind resume review techniques and implementing structured interview process can help mitigate unconscious bias and promote fairness in hiring decisions. And it looks like we have enough time for one more question today, so here it is. What should employers do if they receive a complaint of discrimination from an employee who's unwilling to provide specific details or evidence? Now, that's a tough question, right? When there's not evidence to go off, that does make it tough. So, when an employee raises a discrimination complaint but is unwilling or unable to provide specific details or evidence, it can present challenges for employers in addressing the issue effectively. In such cases, it's critical for employers to communicate openly with the employee, express a willingness to listen and investigate their concerns, and offer support and resources to assist them in providing more information if they feel comfortable doing so. Employers should also ensure confidentiality and sensitivity throughout the process to maintain trust and encourage employees to come forward with their concerns. And that brings me to my closing remarks. I want to thank you all for your participation today. You guys had some really good questions. I'd like to acknowledge my law school, Purdue Global Law School, for the great information that they've bestowed upon me. And I've left my contact information on the slide if you'd like to follow up with any other questions or give me a call or text, and I can try and help you out as needed. And again, thank you for your time today, and we'll see you next time.